Okay, so thanks very much everyone and welcome to today's webinar, the National Redress Scheme Essentials for CLCs. As I mentioned before, I'm Ange Halen. I'm the Operations Coordinator at Community Legal Centres Queensland. Before we get started today, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they are the Turrbal and Yuggera people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians joining in today. So as I mentioned earlier, today's webinar on the National Redress Scheme is being presented by Trina Williams and Warren Strange of No More. They will be discussing the National Redress Scheme for Institutional Child Sexual Abuse, which has now been in operation for 1 year. And have been helping survivors of child abuse to access their options for justice and redress, including under the scheme. So in this webinar, Trina Williams, Senior Lawyer in No More's Brisbane office, and Warren Strange, No More's Executive Officer, will discuss what No More has seen in the first year of the scheme, including some of the outcomes for No More's clients, as well as important emerging issues CLC workers need to be aware of. Trina and Warren will also address ongoing issues around the design of the scheme and the changes recommended in the recent report of the Joint Select Committee of the Federal Parliament. Okay, so I'll get them to tell you a bit more about themselves if they wish to when we hand over in a moment. But as today's webinar is being recorded, we'll have the recording available to download later today or tomorrow. The PowerPoints and other materials have been emailed out to everyone who registered and are available to download from our website. And you can also grab them from the handout section of the GoToWebinar control panel if you'd like to check there. To ask questions, you can type your question into the question box on the control panel, and we'll read your questions out at the end of the session, and then Warren and Trina can answer them. Hopefully. We'll hold the questions until the end of the presentation, but feel free to pop them in as you think of them. If you're having any issues with sound or tech, or if we're a bit too quiet and need to move a bit closer to the microphone, just let us know. Use the question box to advise me, and I will do what I can to sort it out. I'll now hand over to Trina and Warren and speak to you again at the end of the session. Thanks. Go ahead, folks.
Thanks very much, Anne. Good morning, everyone, and we're very happy to be here this morning to talk to you about our legal service and about the National Redress Scheme and what we've seen in the first year. Sorry, we're just getting our PowerPoint underway here. Thanks. We'd like to also acknowledge the owners of the lands on which we're meeting around Australia today, and to pay our respects to the custodians of those Aboriginal and Torres Strait Islander lands and elders past, present and emerging. Today we're going to talk about the National Redress Scheme and what we've seen in the first year of operation. Trina will do the lion's share of the presentation because she's working with these cases and clients all day, every day. Many of you will have known that Leanne Scoynes was the managing lawyer in our Brisbane team. Trina's now acting in that role. Leanne left us last month to accept an appointment as a casual magistrate, and that's a tremendous honour for her and a wonderful recognition of both her legal skills, but also, I think, our broader community legal sector for someone to achieve an appointment like that. But Trina's stepped in behind Leanne and is doing a wonderful job managing our legal team here in Brisbane. The overview slide is what we're going to talk about today. I just wanted to make some introductory comments about the National Redress Scheme. When the Royal Commission into Institutional Responses for Child Sexual Abuse was conducting all of its investigations and work, it looked at what survivors need to have in place to obtain justice. And it came up with the recommendation that there needs to be a national redress scheme independent of the institutions where people experience childhood sexual abuse. That was a keynote major recommendation, and it was one that we'd advocated for in our law reform work, and one that we'd strongly supported. And the Royal Commission came up with a very carefully designed scheme that paid regard to all the evidence, all the experiences that it heard, all the policy work, all the contributions that were made. So it was a very carefully designed blueprint for justice for survivors. On that note, I should just comment for those who mightn't be aware that this morning the Court of Appeal in Victoria delivered its decision in relation to Cardinal Pell's appeal against his conviction and dismissed that appeal. So by a majority of 2-1, haven't yet read the judgment or the summary obviously, but I understand the majority judges accepted that the jury were quite capable of being satisfied beyond a reasonable doubt as to the Cardinal's guilt. So that means his sentence stands. He obviously may consider an appeal to the High Court, but as things stand at this stage, he's been convicted by a jury and he's had his appeal against conviction dismissed by a majority of the Court of Appeal. So a very significant day for survivors today. We'll see a lot about that in the media. Going back to the National Redress Scheme, as I said, we've strongly advocated for an independent national scheme to take the question of redress out of the hands of institutions, many of whom refuse to entertain any redress claims at all, or provided inadequate amounts or inconsistent decisions, and really stripped people of many of their fundamental rights and engaged in very re-traumatising processes for anybody who wanted to seek redress. So the previous environment was highly unsatisfactory. Ultimately, the current federal government, or the previous federal government, determined to support a national scheme, and we commended them on the leadership of doing that, because it's far better than the options of having each state run their own scheme, to have a national consistent scheme. Unfortunately, the scheme that we now have has some significant departures from what the Royal Commission recommended. And really that came about in the process of having to negotiate with the states to get them on board. And there appears to have been some trading around issues and features of what this scheme will look like. Important things such as the cap on redress, which the Royal Commission recommended as 200,000, has been reduced to 150,000. So it has changed. There are also some issues in its implementation. It's been running now for 1 year, and just to put that in context, it's the largest redress scheme of its kind that's ever been implemented anywhere in the world, and it came about in a huge hurry, the way the history of the legislation leading to the scheme starting on 1 July last year. The final bill was passed by Parliament in the middle of June. Some of the supplementary or subordinate instruments like the assessment framework and the rules and things like that, I think we got those at about 3 o'clock on the Sunday afternoon, the day before the scheme started. So it all came together in a huge hurry, and it was ultimately supported by the crossbenchers in the upper house on the basis that it's not the scheme we want, but it's better than nothing. So we'll support it and we'll try and work to improve it once it's in place. So there are always going to be, in any sort of policy undertaking of this magnitude, it's never going to be perfect from day one, and there are issues around the implementation that we are advocating about as well. But the point I want to make is that we're now only just now starting to see outcomes for people that we've worked with to lodge their applications, and some of those outcomes have been very positive and very life-changing for people, and they represent outcomes that they would never been able to achieve otherwise. These are often people who, for one reason or another, are unable to bring a common law or a civil claim. And I'm thinking of one client who we've been in touch with came to us early in the life of the Royal Commission to help her engage with the Royal Commission. We did that. She's a client who presents with many mental health issues and many challenging behaviours and issues impacting on her life. We endeavoured to refer her to a number of law firms to investigate the prospects of a civil claim, and despite doing supported referrals, those relationships didn't work out and were unable to be maintained. She came back to us last year to look at a redress claim, and we acted for her in that respect. We supported her with our legal team, with our social workers, and with our Aboriginal engagement team, and we were able to lodge a redress claim that had a successful outcome. And she was very pleased with that. It's enabled her to put some money away in a deposit account. She's been able to buy herself a caravan, which was something that she wanted to do. And she specifically commented to us upon getting her award that she was very grateful that we hadn't given up on her over the years and we've been able to help her. And, she was one of Trina's clients, and those sorts of outcomes and ones that people would not have been able to get but for this scheme. So I think it's important. You will hear a lot of criticism in the media, and much of that is justified around aspects of the scheme's operation, but it's important to bear in mind that it's a hell of a lot better than what existed before for survivors, and it does present a pathway to justice, and one that we're committed to continuing to work to improve. We'll talk today about the report of the Joint Select Committee of the Federal Parliament. That was the committee led by former Senator Darren Hinch. They produced a report in April of this year making 29 recommendations to change the operation of the scheme. Some of those require legislative change. That won't be easy because of what I mentioned about the states having to agree, and they've all referred their powers, so it's not a straightforward issue of achieving legislative change simply by getting the lower and upper houses of the federal parliament to agree. It's much more complicated than that. The Joint Select Committee made some fairly pointed comments about the failings of the scheme at the moment and the opportunity to now get it right. And Trina will touch on some of those specific recommendations as we go through today, comparing how things are at the moment and what the committee has recommended. After that, I was going to talk about a decision of the Queensland Supreme Court in the case of TRG and Brisbane Grammar School. One of the key things, if you are ever advising or providing information or working with a client who may be eligible for a redress claim, one of the key legal issues is to remember that redress is an alternative to common law or civil litigation. Someone who accepts a redress payment, it's a condition under the legislation that they execute a deed releasing the institution and their officials from any future liability. So they are signing away those future rights, and they need to be making that decision, understanding those implications, because this is an area where we know people might be very happy to pursue a redress claim, particularly if that can happen expeditiously, but their views around that may well change when they realise that somebody who went down the common law path might have received a much higher reward of damages. Redress is not compensation, it's not compensatory in the same way as common law damages, it's a recognition payment, and because it's a much more straightforward process with a lower standard of proof, it is a true alternative to common law litigation, but the trade-off is around the outcomes. So it's something to be very mindful of, and you need to also understand that there is a lot happening in the space around civil litigation reform, and I'll be talking about particularly the power of courts to set aside past settlements. So there are many opportunities now available to survivors to seriously look at the prospects of a common law claim before determining to go down the redress pathway. That's something that we strongly encourage all of our clients to do if they're able and they're in a position physically in terms of their health and their age to be able to do that. At the end of the day, redress will still be the right pathway for many of those clients because they won't have good prospects with a civil claim, but ideally that's a decision that's best made up front. Okay, I'll hand over to Trina now to talk you through what we're seeing in the first year of the scheme.
Good morning, everyone, and thank you, Warren and Anne. These are some of No More's key objectives. We've expanded our team to over 100 staff within the first year of the National Redress Scheme, and we now have offices in Brisbane, Melbourne, Sydney, and Perth. I will discuss what we have seen in the first year based on my experiences as a lawyer at No More, but note that we are still in early days. The NRS website reports that as of the end of July, it has received over 4,500 applications, has made 313 redress payments, and an additional 130 offers. It is expected that this number will significantly increase over the next 9 years. Our numbers show how busy we have been. This data is current as of June 30th, 2019. There was a tsunami of clients within the initial months of the redress scheme. We've completed intake for a little over 4,500 clients. To put that in context, in No More's first 5 years supporting clients through the Royal Commission, we helped only 9,000 clients. We are at over our halfway mark within 1 year alone, which is why we needed a significant increase in staff. As to client numbers, Queensland is leading the way at 28%, which is much more than our share of the population of 22%. Of note, 60% of No More's current clients did not engage with us during the original Royal Commission proceedings. The percentage of clients that were previous No More clients was higher in the first few months of the redress scheme. This is a snapshot of survivors using No More services at the moment, and this data is updated as of the end of June. 22% are priority clients. Priority clients are defined as those with, for example, a life-threatening illness, such as stage 4 cancer, organ failure, serious mental health issues, those that are very elderly and frail, non-Aboriginal clients born before 1943, and Aboriginal clients born before 1963. We have had clients with terminal illnesses that we were able to complete an application for within 4 to 5 days. A few have unfortunately passed away. We prioritize clients that may pass away sooner because their relatives cannot lodge an application once they pass away. Being alive at the time of lodgement is a requirement of the scheme. This is obviously a liability issue in legal practice due to the issues with succession rights. As a lawyer, one of the first things I do with a new high priority client is try to determine how serious their condition is and whether efforts should be made to get an application in immediately. As you can see, 25% of our current clients identify as Aboriginal or Torres Strait Islander. This number is higher in Queensland. Interestingly, this is also the highest figure we have ever seen in our history, which includes the Royal Commission statistics. Overall, a majority of our clients are middle-aged or older. As Warren said, the scheme has been operating for a little over 1 year. There have been several versions of the applications, and modifications were made based on feedback from applicants and those supporting them. As Warren also mentioned, this April, the Joint Select Committee released a report that made several recommendations to improve the scheme. I just want to point out a few elements of the scheme alongside the relevant Joint Select Committee recommendations. What does the scheme offer? A survivor can accept any or all of the 3 listed options when an offer is received. Our experience is that once applicants return their signed offer form, is that they are receiving funds quickly after the paperwork is received. Survivors can receive a recognition payment of up to $150,000. The average is reported at being a little over $81,000, which is assessed based on a specific framework, which I'll get to shortly. The Joint Select Committee recommends increasing the limit to $200,000 with a $10,000 minimum. This would be more consistent with the recommendations of the Royal Commission. The counseling benefits being offered by the scheme depart significantly from the Royal Commission recommendations. Currently, depending on the jurisdiction, survivors are being offered a small monetary payment between $2,500 and $5,000 and some counseling services through approved providers. However, the Joint Select Committee recommendations are in line with the Royal Commission recommendations, including offering lifelong counseling benefits. In our experience, the majority of survivors have accepted counseling benefits, while around half have requested a direct personal response. Regarding eligibility or who can apply, at the moment, a survivor must be an Australian citizen or permanent resident to be eligible. The Joint Select Committee recommends that 3 additional groups also be eligible, including child migrants, non-citizens or permanent residents living in Australia, and former Australian citizens or permanent residents. As a legal practitioner, it is critical to understand that only one application can be made. Although the process was supposed to be non-legalistic, it has generally been difficult to navigate, which makes obtaining legal advice and support through the application offer process even more crucial. One of the main components of the scheme is the monetary payment, which is assessed based on the information provided by the applicant in parts 2 and 3 of the application. The payment is currently being assessed pursuant to guidelines that sit behind this framework. We cannot see the guidelines as they are not publicized, and it is a criminal offense to publish them. Because the process is just beginning and only close to 500 applicants have been made offers nationwide, we only have very limited insight. However, no more is building up insight based on our experiences. We have seen many issues arise from the published assessment framework, several which were addressed in the Joint Select Committee report. The maximum monetary payment available under the scheme is $150,000, which is only for the most extreme of cases. Basically, the specific type of abuse experienced by a survivor determines the first 0 to 100,000. For example, for exposure, there's basically a maximum of 20,000. And this could include like seeing other children abused, the threat of abuse, or grooming. For contact abuse, which could include, well, basically touching or things of that nature, there's a maximum of $50,000. For penetrative abuse, a survivor can get up to $100,000. There's no clear guidelines regarding this definition, but we are generally presuming that it includes instances where someone inserted something into a part of the survivor's body or made the survivor insert something into a part of the perpetrator's body, like a penis, finger, or object. Once the type of sexual abuse is assessed, per the guidelines, a determination is made regarding whether extreme circumstances existed. A survivor is not eligible for extreme circumstances unless there was penetrative abuse. Penetrative abuse in extreme circumstances attract a maximum of $150,000. We do not have enough information from clients' offers at this point to identify how the assessment of extreme circumstances is being made, although we have seen a few maximum offers come through. The matrix is linear based on the type of abuse versus taking the duration or impact into account. Potentially a survivor that experienced penetrative abuse one time could be offered the same or more than a survivor that suffered more frequent abuse and stopped short of penetrative abuse. As a result of the assessment framework, we are finding that we as legal practitioners are required to have very direct, personal, and difficult discussions with survivors that may have been seeking compensation through the redress process to avoid revisiting the details of their stories. This has been one of the most challenging hurdles in our legal practice, as even Royal Commission statements and past redress applications may not contain this level of detail. In my practice, I've been finding myself having to advise certain clients of the potential monetary cost of non-disclosure of the full details of their abuse, it's very difficult. However, it's my job to advise them that non-disclosure may cost them a significant amount of money. Even when this is done with the support worker or very delicately over several visits, it doesn't always feel right, especially for a process that is supposed to be trauma-informed. The Joint Select Committee recommends the following changes to this assessment framework and the associated processes. First, it recommends that a new assessment framework be developed, which more closely reflects the assessment matrix recommended by the Royal Commission and which acknowledges that the type or severity of abuse does not determine the impact of sexual abuse for the individual. And that if a new assessment framework is implemented, that applicants who were assessed using the current framework be reassessed, which is good. Next, they recommend that the government clearly communicates to the public how applications are being considered and the grounds for determination, and that the government also publicly clarify terms in the assessment framework. Finally, the Joint Select Committee recommends that if the current assessment framework remains in place, that in extreme circumstances, acknowledgement be available to all applicants, even those that did not suffer penetrative abuse. Each person is different. This may be their first disclosure. As lawyers, we strive to be trauma-informed while doing our best job of acting in the client's best interest. This process can be very difficult for clients, which emphasizes the importance of them obtaining independent legal advice when completing an application. Sorry, wrong one. These are some specific things we experienced with the application form itself. Part 3, which is essentially an impact statement, was originally shared with the relevant institutions. This raised concerns for some survivors, which resulted in the application being changed to require consent for Part 3 to be shared. The survivor must now actually tick a box to consent. Regarding prior payments, based on offers we have seen so far, prior payments are being deducted and indexed. However, it is too early in the game to know how certain payments will be handled. We take steps to argue that certain payments, such as legal fees, should not be deducted. If available, we attach documentation, such as relevant settlement documents. This could be very important if a client has received a significant settlement and half of it went to the lawyers. Based on the few offers we have received, the entire payments from the Ford redress scheme in Queensland appear to be considered a prior payment, even though the first $7,000 was assessed, regardless of whether survivors disclosed sexual abuse. We, in some cases, have been attaching Ford redress records, if they're available, in some cases, to show which institutions the survivor was actually paid for. This can get complicated, and there are no clear guidelines regarding how these prior payments will be handled when the survivor was abused in multiple institutions. The indexing of prior payments has been a concern noted by many clients, as they felt that the payment was inadequate at the time, and indexing is compounding the injustice. The Joint Select Committee recommended that the redress scheme and government revisit the practice of actually indexing these payments. We have seen a few issues also with statutory declarations in our office. I have learned that it's very important that the statutory declaration be complete. It has been modified, the version right now has been modified from the original version for simplicity. The applicant's name, address, and employment must be filled out completely. The person witnessing the statutory declaration must complete all details, including their name and address. We are aware that statutory declarations have been sent back for incompleteness on both bases. These are some issues we've been seeing with the application process. In our experience, applications are being put on hold when the applicant requests it. For example, to be able to pursue a civil claim or to provide more information, or when they are required to wait for their institution to join or for another institution to take responsibility for their institution. An example would be a defunct institution. We do not have a clear understanding of what the outcome will be when an applicant decides to modify their institutional information in order to allow their application to proceed. We do know that the NRS will allow this. Regarding participating institutions, all state and territory governments and 51 non-governmental institutions representing more than 40,000 sites across Australia have joined the scheme. All institutions are being strongly urged to join, and a name and shame list is actually available on the NRS website, which is being updated all of the time. In my practice, I have called the scheme to inquire about institutions that don't come up in the search engine, and I have been advised by them to lodge the application so that the NRS can actually approach the relevant institution. An example is a Catholic institution in PNG during the time when Australia actually was running PNG. In its report, the Joint Select Committee recommended that governments place and maintain pressure on all relevant institutions to join the scheme. That government consider penalizing relevant institutions that fail to join the scheme with processes such as suspending their tax concessions and charitable status. Currently, if a survivor discloses that they were abused in a defunct institution, the application is being put on hold until the 30th of June 2020, or until another institution takes responsibility. I have been finding that this process is causing great anxiety for some clients, especially those that are ill. We've been asked by clients to withdraw the defunct institution in some circumstances, but are not clear on how this will impact the overall assessment. The Joint Select Committee recommended expanding the circumstances in which the funder of last resort provision applies so that relevant participating institutions act as the funder of last resort more often. As I touched upon earlier, we are not aware of how extreme circumstances are being determined. We are attempting to discern factors that might elevate a claim into this category, and will gain a better understanding over time. In the meantime, in practice, we are trying to provide as much relevant detail as possible in Part 2. regarding physical, emotional, and sexual abuse, including the duration and frequency, as well as factors contributing to institutional vulnerability. The Joint Select Committee recommends the additional extreme circumstances assessment be available to everyone regardless of the type of abuse experience, which would be very helpful for our clients. I just wanted to touch on serious criminal convictions and people that are in prison. We have not had any experience regarding the outcomes of applications by survivors that have had serious criminal convictions, but we are waiting on several. However, I do have some insight into the process. If a person indicates they have been sentenced to prison over 5 years, the NRS will send a consent form to obtain a criminal history report and ask that the applicant complete a brief additional form where they may explain the nature of their crimes and how they have been rehabilitated. There is an opportunity to include attachments and even submissions. Our practice is to include any evidence of rehabilitation. The survivor only gets one shot. Watch this space. The big issue especially, it is a big issue especially since many applicants with serious criminal convictions were actually abused in Queensland youth detention centers, which arguably resulted in their continued incarceration. Currently, a person that is in jail must wait until they are released to apply. The Joint Select Committee recommended allowing survivors in jail to apply for and receive redress, unless providing redress would bring the NRS into disrepute or adversely affect public confidence in the scheme. This is the same test currently being applied for people with serious criminal convictions. Regarding review, excuse me, we have not gone through the entire internal process for a client yet, so cannot offer much insight into the process or the outcomes. We do know that there is no guarantee that the outcome won't be worse, and that additional information cannot be submitted once an initial offer is made. The Joint Select Committee recommends allowing an applicant to submit additional information during the review up until the time the payment is actually made, that the review does not result in a lower payment, and that the government must closely monitor the timeliness of internal review determinations. Regarding payments, and this is more in the area of our financial counselors at No More, but we do know that there has been a lot of protection for payments negotiated for survivors. We often advise clients to open separate banking accounts. There's no need to really actually provide bank details on the application because survivors are being asked to re-provide their bank account details when they accept an offer. Okay, in my practice, I'm hearing a lot of frustration from clients who have lodged redress applications regarding the processing times for applications and offers. It is hard to manage expectations as there is currently no clarity. The Joint Select Committee is recommending a more transparent process, including keeping applicants up to date on the progress of their applications, having a process where the applicant can indicate that they should be a priority and that the NRS publish data regarding processing times. Currently, no published guidelines regarding how the NRS prioritizes clients. Currently, there are no published guidelines regarding how the NRS prioritizes clients, although they have indicated that terminally ill and elderly clients are being accelerated if possible. We're seeing some issues with high priority clients who were abused in defunct institutions because obviously they're not. Although they're being prioritized, they're not being put through, and I'll touch on that a little bit more. I just wanted to give you a couple outcomes. I don't have time to go too far into this. We've seen the maximum of 150 come back to our office, as well as 100,000 being assessed for foster care abuse survivors in Queensland. We've seen 50,000 assessed for a survivor who suffered sexual contact abuse one time in an orphanage, along with significant physical abuse. For a more specific story, the No More team recently assisted a 97-year-old woman who, starting as a 6-year-old child, experienced nightly sexual abuse in the orphanage she lived in for over 2 years with related physical and emotional abuse. She was unable to leave the orphanage and had no access to family or friends. She accepted an offer of $100,000 from the NRS, as well as access to counseling service and a direct personal response on behalf of the institution, based on her advanced age. She was planning to give some money to her 2 grandchildren. She stated that the redress money was not so much about the money, but rather an acknowledgement to those who offended and to all of us who suffered. She said that it had taken her 91 years to get any recognition for wrongs to be righted. No more has been advised that this client passed away recently. Overall, since applying for redress has in fact become a legal process, survivors run the risk of not putting in their best application unless they seek legal advice. They also risk not getting an application in at all if they are sick or elderly. We are seeing people benefiting from legal advice and legal assistance on a daily basis. I know Warren touched on civil claims quite a bit, so many applicants are also considering civil claims. It is a very important decision. It is important to remember that a redress payment is not compensatory like common law damages. If there's one legal issue we must really address as practitioners, this is really it. Imagine a client who receives redress but is not meaningfully advised of their common law rights, seeing a newspaper headline a few years down the road that reveals that several of their classmates who experienced similar abuse were compensated for an amount much higher than their redress payment. They will possibly be looking to you for an explanation. So that's just all I really wanted to point out on that. It's a big and hard decision to make as the civil litigation landscape is shifting, which Warren will address further. And no more will we encourage people to seek expert advice before accepting an offer. Thanks.
Thanks, Trina. That was a run through on what we've seen in the first year, and we've seen a lot. Our service will continue to advocate strongly for reform of the National Redress Scheme. We were very involved in the processes of the Joint Select Committee. We gave evidence on a couple of occasions. We provided several submissions and other pieces of information in response to questions that we took on notice, and all of our advocacy work, our service and our evidence was referenced over 100 times in that final report of the committee. So there's a high degree of correspondence between the changes we're advocating for and what the committee has recommended. So we're now working to do what we can and to partner with other services and other stakeholders to try and persuade our governments to pass the legislation and make the other decisions that are necessary to implement those changes. Civil litigation, as we both touched on, it's a real threshold issue for survivors when they're thinking about their redress options. And I just wanted to note, to put things in context, that our service is funded to advise people and assist them to make informed decisions around their redress options. We're not just specifically funded to steer people into the National Redress Scheme. So we have those conversations around what the options look like with the national scheme, with other schemes, victims of crime compensation schemes, institutional schemes that continue to exist, and common law and civil claims, and try and walk the client through what those options are so they can make a decision. If they want to go down the common law pathway, we'll refer them out to private firms that are on our referral panel and meet our criteria so they can get that expert advice. But some of those will come back to us, but we're not simply there just to funnel people into the redress scheme. We're there to help them make the best decision that's the right one for them. Deciding on common law claims is not always easy because, as we've said, it's a shifting landscape. There's a lot happened with reform. We've had limitation periods removed around Australia for, at the least, claims of child sexual abuse and more broad claims, including serious physical and connected abuse in some of the other states, but not yet in Queensland. And that's something we've been advocating for, to broaden that exemption. So limitation periods no longer apply. They were previously a huge barrier. And because they applied for so long, it meant that many survivors who were looking before things like the National Redress Scheme existed to try and get some justice from institutions basically accepted very small amounts. And we've The majority of those people accepted settlements probably under $40,000. The forward redress scheme that operated in Queensland, the maximum payment was $42,000, and it came with a requirement to sign a deed relinquishing future rights, although governments released people under those obligations. But that's the sort of landscape that existed around redress. People got nothing like what they would get by way of common law damages. If they attempted to sue, they were invariably met with the limitation defence, and made it very difficult to pursue those claims. The TRG and Brisbane Grammar case came about because when our limitations law was removed, the former independent member for Cairns, Rob Pine, MP, had brought his own private member's bill before the House ahead of the government bill to bring these reforms in, and it included a provision to allow past deeds of settlement to be set aside in claims that were previously statute barred. And that was groundbreaking reform. The government didn't support it, but the opposition, the Liberal National Party and the minor parties, the Katter Party and others did, and under the previous parliament, where the numbers were very finely balanced, they had the numbers to carry the day on the floor of Parliament and enacted this reform. We're now seeing it taken up around Australia. It's been picked up in Western Australia and the Northern Territory already. Tasmania has a draft consultation bill out. The Victorian Attorney-General has announced her intention to enact these reforms in Victoria. And there's a private member's bill being introduced by a former CLC person who's now a member of the South Australian Parliament. So these reforms are generating momentum right around the country. The amendment really operates as an exception to the legal principle of res judicata, of a judgment made final, and it allows a judgment or a past settlement in Queensland to be set aside if the court decides that it's just and reasonable to do so in one of these cases. And TRG is the first and the only decision that we've had here in Queensland, and it was a matter brought before the Supreme Court seeking the application of the court's power to set aside a previous settlement. In that case, the plaintiff was one of, unfortunately, dozens and probably hundreds of boys attending Brisbane Grammar School who suffered abuse at the hands of the notorious pedophile Kevin Lynch, whose criminal behaviour has been well publicised over the years. The plaintiff came forward in 2001. You'll remember, those of you who were around at that stage, that that was when publicity about what Lynch had been up to started to be generated, and people started to come forward in huge numbers to complain about what he'd done to them. The plaintiff was represented by lawyers and barristers, went through a formal mediation process and ultimately settled their claim for $47,000. These cases will always turn on their own facts, and it's important to understand something of the facts in this case. As I said, the plaintiff was represented by lawyers. His claim changed quite significantly in terms of its potential quantum during the life of the lawsuit and the negotiation. Obviously, the limitation period was pleaded in defence by the school, but his claim went up and down in terms of what he was seeking, and in September 2002 he got advice from a QC and another junior counsel that his range of damages was around $95,000 to $167,000 with a discount of 40 to 50%, given the difficulties in proving liability, bearing in mind that the plaintiff was suing the school, they're not suing Lynch or his estate. That would be a clear case of liability. They were attempting at the time under the laws of vicarious liability, which were very difficult to sheet home to an institution, to prove the case against them. So that would have meant, practically on council's advice, a range of around $48,000 to $100,000. Ultimately, the claim was settled for $47,000 plus costs on the district court scale. Justice Davis was the trial judge, and the case is now under appeal, so it'll be interesting to see what the Court of Appeal makes of legislative provisions and the application of them to the facts here. Likely to be heard later this year, I would think. There are some general principles which I've listed on that slide. There's not a general presumption that these amendments mean that deeds will always be set aside or should always be set aside. There has to be a balanced approach. Just and reasonable requires consideration of the interests of both parties and not just of the plaintiff. And he's come up with a list, or considered in his judgment, a number of general considerations which will obviously be used for guiding how facts apply in previous cases. Some of the sorts of things that he looked at that might be relevant to setting aside is whether there's been high-handed behaviour by the institution, a summary dismissal of a claim that otherwise had some good prospects, but for the limitation defence, unequal bargaining power, claims being settled for a nominal amount, and generally a settlement that's unfair. And here, bearing in mind what I've said about legal representation for the plaintiff and the advice that the plaintiff had from very experienced counsel about the likely quantum of damages on common law principles, it's very different to some of the cases that we've seen in our practice where survivors have signed away all of their rights for amounts like $2,000 and have been unrepresented and have had to participate in processes that are clearly unequal and replicated the power imbalance which at its heart underlies all sexual offending against children, people being brought in to sit before a panel of 5 or 6 figures from a religious institution. And it was very powerfully explained to me by a client one day who had settled his claim for a very small sum. And he said he was brought into a room, he had to sit down with 5 of the brothers of the religious institution responsible for his abuse. And he said the moment he did that, he became the 8-year-old boy again in that environment, and he would have said anything and signed anything to get out of there as quickly as he could to reduce the very real and serious trauma that he was experiencing. So there are other situations that we're aware of. In one state, not Queensland, a major religious institution ran their internal process for years. Survivors were told that if they engaged lawyers, they could not participate in this process. And that advice was conveyed to them by lawyers acting for the church. So the irony in that stands strong. There are a number of factors.
On the slide, click on the slide.
Going to the next slide, which were listed by the judge, and I won't go through those because of the time. We want to leave some time for questions, but it's well worth reading the judgment. It's an interesting application of the principles. There is one other case that has been decided in Western Australia. It's only at the district court level, although it was the chief judge of the district court, involving the Christian brothers. Quite different facts. The survivor had been through 2 previous settlements, one for $2,000 in the 1990s and then another one for $100,000 during the life of the Royal Commission, when after the Christian brothers were subjected to a number of public hearings about some truly terrible institutions in that state, they determined that they should reopen these past cases and afford some better justice to survivors. And the plaintiff in that case was given $100,000, but was successful in applying to have that deed set aside. Interestingly, unlike Brisbane Grammar here in Queensland, Christian brothers in Western Australia did not oppose that application and agreed to abide by the order of the court. And that decision made it clear that the court would look very carefully at the circumstances at the time of the settlement. It's worth noting in Western Australia they had some very harsh limitation laws, and basically historical claims were completely statute barred. There was no opportunity to have the limitation period extended as there was in Queensland. So it's something to be mindful of. Even though someone may have signed away their civil rights in a settlement years ago, there is now the prospect, at least in Queensland and in some other states, of having that case reopened. The laws around the institutions, duties of institutions, and the ability to sue unincorporated institutions are changing. There is a bill before the Queensland Parliament at the moment, a government bill which we expect will be passed and will enact some of the Royal Commission's recommendations around that. So it just makes it all the more important that people make that decision about redress or a common law claim up front and with the benefit of informed advice. That's a headline from Western Australia. As Trina said, redress is not compensatory, and there are some significant settlements and awards being made around Australia. That's perhaps the high water mark, but that's the sort of thing that survivors see, and will be thinking about their own options, or should be thinking about their own options and what's best for them. Our website has a lot of information, links to other websites, including the National Redress Scheme, which produces some very good fact sheets about the scheme. So there's a lot of information on there about the scheme and about our services. And that's where you find us at the moment. We are moving offices in Perth to our permanent home very shortly, so we'll put that up when we're there. But we're very happy to always speak to people about any issues or queries, generally or specifically, and how we might be able to help. Questions?
Great, thank you so much. We've got a couple of questions here. They're really very similar from Geordie and Siobhan. Do you know how redress payments affect someone's Centrelink entitlement? So if it's not compensation, where does it fall in terms of being seized in bankruptcy or assessed as income by Centrelink? So I'm sort of assuming that might be a question for your financial advisors.
That's what I was going to say, is we do have a team of financial counselors for No More Now. If you're a client, or if you wanted to call through to our 1-800 line or contact me directly, I can put you in touch with them, and they would be able to more specifically answer those questions. And I also know the Centrelink website has some good information. I'm sorry, that is just not our forte as lawyers. So, but that's why we do have financial counselors, and I'm glad those questions were asked, because that highlights why we need financial counselors in our office.
Okay.
There are some protections in the legislation for exempting redress payments from things like income tests. It gets a little bit more murky around asset tests. We've been in touch with all the state governments around treating the payments as special payments exempt from consideration for housing, social housing entitlements. That's an emerging issue, but the more we dig into some of those financial issues, the more complex they can be for survivors. So, as Trina said, it's important, and that's why we've been able, with a grant from the Financial Counselling Foundation, to put on a small number of financial counsellors. We've also produced a kit for community workers, which has some more information about those issues. We worked with the Financial Rights Legal Centre, and you'll see that under the Financial Counselling tab on our website. Under that page, there's a link to that resource, and it's a reasonably straightforward guide to some of the issues that might arise, and it's written with community workers in mind if you're working with somebody who's going to be receiving a redress payment. So that's probably the starting point, and our counsellors can help with more specific advice.
Okay. All right, and we've got one other question here from Vinay. So they've basically asked, well, the crux of the question is, why do you need to wait until the victims are out of prison? So how would one's criminal conviction bring the NRS in disrepute? Isn't the NRS meant to address past institutional abuse, and shouldn't everyone have access to the scheme no matter what followed?
We hear you, and we agree, and we strongly advocated that there should not be classes of survivors. The Royal Commission made no such recommendation around prisoners, but going back to the point I was making about negotiations with the states, that seems to be where that policy position developed during the genesis of the scheme. And I expect that some of the states were very concerned about some potentially notorious criminals who are survivors having access to the redress scheme. So it's in the legislation, it's there, we've advocated for change, the Joint Select Committee has made recommendations around that, but it exists at the moment, and it stymies applications from survivors who are in prison unless they meet a couple of exceptional circumstances tests. And we've made some applications, but we're yet to see how they have been determined. So we'll keep working on it. It's a significant issue because here in Queensland we assisted nearly 1,000 people in prison during the Royal Commission who are survivors, and that's a really startling number who are prepared to come forward in that environment and disclose their sexual abuse and seek some form of justice. So we know that many people in the prison environment have got this experience in their childhood, unfortunately.
Okay, and we've got one other question from Geordie. Is there any pressure being exerted on institutions to join the redress scheme?
The government continually talks about engaging with institutions and urging them to join the scheme. We did submit to the committee that we'd like to see more information about what government is doing. I have heard some fairly strong statements from both the current Minister and the previous Minister for Social Services about that, but they haven't meant that all relevant institutions have joined. I've talked about Brisbane Grammar. They haven't as yet joined the scheme. They haven't committed to joining the scheme. And some of the suggestions that have been made by our service and by others to look at issues such as government funding of institutions. There was a childcare institution in Tasmania that said we're not joining the scheme. Tasmanian government's response was, that's a matter for you, but we're not funding you any further if that's your position. They pretty quickly did an about face and decided they would be joining the scheme. So there are levers that government can pull. Some services and survivor support groups have advocated for reduction or removal of institutions' charitable status if they don't join the scheme when claims arise. And I think things like that have to seriously be looked at, because we do have institutions. Jehovah's Witnesses is one where the Royal Commission examined them and found hundreds of claims of sexual abuse have been made over the years. They have no redress scheme. They haven't yet joined the scheme. There have been no particular moves indicating that they are likely to join the scheme that I'm aware of. So we'll continue to advocate for government to do everything it can to persuade those institutions to join. They can't compel them. They've taken that view as a matter of constitutional law. But there are perhaps other things, those levers that I mentioned, that they can operate to impact on decisions.
Okay, we don't have any other questions, so we'll move on to wrapping up. Thank you so much to Warren and Trina for popping into the CLCQ office to give us a bit of a rundown on what's going on at No More at the moment and for the past 12 months today. We will be putting the recording of this webinar up, as I mentioned earlier, either later today or possibly tomorrow, and there will be a survey that comes out post-webinar as well by SurveyMonkey. If you can complete that and give us any feedback you'd like to give, we'd be appreciative. that's everything for today. Thanks so much to everyone for attending. Have a great day all.
Thanks, everyone. See you at the conference, hopefully.